How much notice is required for tenants in property management? Have you ever wondered how much notice a landlord must give tenants before making changes? This is a key aspect of tenant management and communication. Understanding notice requirements can help both landlords and tenants maintain a good relationship. The amount of notice needed can vary based on the type of tenancy, local laws, and the reason for the notice. Typically, landlords must provide written notice to terminate a tenancy or address specific issues. The law sets minimum notice periods that cannot be waived by the tenant. For month-to-month tenancies, a common minimum notice period is 30 days before termination. This means if a landlord wants to end the agreement, they must inform the tenant at least 30 days in advance. When it comes to lease violations, such as non-payment of rent or breaking lease terms, landlords usually must give a written notice. This notice should specify the problem and include a deadline for the tenant to fix it. Depending on local law, this period can range from 3 to 30 days. If a landlord needs to enter the rental unit for inspections or repairs, most states requiring at least 24 hours notice. This is important for respecting the tenant's privacy and ensuring clear communication. In cases of foreclosure, tenants must be notified and often receive 90 days notice before needing to vacate, even if they are under a fixed-term lease. This gives tenants time to find new housing and prepare for the transition. Some areas have specific rules for notices related to eviction or lease termination. These often requiring written notice with clear reasons. In emergency situations, landlords may enter without notice, but this should be an exception rather than the rule. Notices must be properly formatted, signed, and dated to be legally valid. Landlords should always have a legal reason to give notice, such as non-payment or lease violation. When it comes to eviction, notices must comply with local eviction control laws when applicable. For property managers, it is essential to check state and local laws to confirm the exact notice requirements, as they can vary widely. Using written notices with clear dates, reasons, and deadlines helps avoid disputes. Keeping records of all notices served, including proof of delivery, is also a good practice. Clear and professional communication with tenants can maintain good relations and reduce misunderstandings. When in doubt, providing more notice rather than less is a wise choice to ensure compliance and avoid legal challenges. Remember, tenants have rights to minimum notice periods and legal protections against improper eviction. By following these guidelines and respecting notice requirements, property managers can effectively manage tenant relations and reduce legal risks while ensuring smooth operations in urban rental properties.